realizing I had a problem. Like I'm not a bad person. I just got an addiction, and I can't do it on my own. I finally realized.
Okay, we're on the record in People versus Jeremy Brokaw. This is file number 256796. The record should reflect that Mr. Brokaw is present here in the courtroom today. If I could have counsel put your appearances on.
Good morning, Your Honor. The record, Michael, on behalf of the people.
Thank you, Your Honor. Richard Truescreen on behalf of Mr. Brokaw.
Thank you. This is the date and time set for a sentencing hearing in this matter. Mr. Brokaw, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, Your Honor.
Mr. Trush, are there any additions, deletions, or corrections to that report?
There are, Your Honor, just a couple of them. So first, and probably the most obvious, is this is a case I inherited from Mr. Baber after the PSI was prepared. So it lists Mr. Baber as attorney of record, obviously. That's now me. So, I mean, everywhere throughout the PSI where Mr. Baber is listed, I just asked it to change to me.
Okay, we'll make those corrections next.
So pre-sentence investigation report, CFJ 145, page 2, indicates 2 days of jail credit. I think by my calculations, there's an additional 10 days. He reports he was arrested on the 20th of the month.
Mr. DeLeo?
I'm sorry, the 10th of the month, which would be the additional 10 days to today's date.
Okay.
$10 days is correct, Your Honor. 10 additional.
Okay, so a total of 12.
Correct.
Okay. Thank you. Mr. Trush?
And then lastly, CFJ 284A, page 3, the criminal justice system, criminal justice section, entry 1 of the adult history indicates that he served 93 days in jail. That jail is actually held in abeyance. He didn't serve any jail on that sentence.
Okay. Mr. Rolla or Mr. DeLeo, any objection to that change?
No, Judge. In fact, that's going to point the out to the court.
Okay, we'll make that correction, just adding that 93 days in jail was held in abeyance. Okay, any other corrections?
No.
Thank you. Any challenges to the scoring?
No.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, other than what's already been indicated on the record.
And do you have any challenges to the scoring?
No, Judge.
Okay. Anything on behalf of the people for allocation today?
Yes, thank you. As unfortunately indicated in the defendant's most recent PSI, this defendant's received numerous prior breaks and opportunities in the past to deal with controlled substance addiction, including January 22, 2018, 7411 deferral on a possession of analogs charge, which by the way is not scored under the guidelines. And far greater concern is when given the opportunity of a delay of sentence on a controlled substance possession of methamphetamine charge, that's number 5 of 6 under the adult history. In June of 2023, instead of taking advantage of this opportunity on his second controlled substance conviction, he then commits the instant offense and loses the benefit of his delay of sentence, all the while not reporting as required to his probation agent, then also indicating positive for controlled substance while on probation on July 15, 2024 and July 23rd, 2024. The people agree with the statements in the PSI indicating that progressive sanctions are warranted in this particular case, and that in addition to some upfront jail time, we would recommend at least 2 years of probation or fully monitor the defendant's progress, or in this case, perhaps lack thereof, whichever is appropriate. Thank you, Your Honor.
All right, thank you, Mr. Trush.
Thank you, Your Honor. I think the PSI here does a good job of balancing some, I don't want to say abnormal circumstances, but Mr. Brokaw presents to the court without a significant criminal history, which would seem to suggest a jail sanction may not be appropriate. I also think that the PSI does an accurate job of indicating at the time the PSI was created, I think it's accurate that he was minimizing his continued use of controlled substances and really downplaying the issue that he had with it. I don't think it's uncommon for us to see that. And I think looking at the criminal history, you can kind of see the progression. In 2022, he has, or I'm sorry, 2017, he has the first controlled substance offense that he has, which is taken under 7411, and he successfully completes that probation and that charge is dismissed. In 2022, we see another case. He's not able to complete that probation successfully. He violates and ultimately loses the benefit of the bargain he had there, being that delay of sentence. And now we have the current circumstance, which sort of overlaps with the other one. So I think it's fair to say from his record, there appears to be a bigger issue than I think he realized that he had. I do think as he presents here today for the court, the circumstances are a little bit different. I think he recognizes now the significance of the issue that he has. The circumstances that brought him back before the court are significant. How he was sort of apprehended and brought back before the court is he was found unresponsive in his vehicle and was transported to a hospital where he was resuscitated and ultimately then taken back into custody. And he reports to me this is an eye-opening circumstance for him. If someone hadn't intervened and if he hadn't been located there, he may not have survived. So I indicate all that to the court because I think the PSI is accurate and was accurate at the time. I think that he does have more insight into the depth of the issue that he has as he stands before you today. I would suggest to the court that a blended sentence is likely appropriate. I certainly think there does need to be a punishment element to it. I certainly think that some jail is appropriate given the circumstances. I would suggest to the court that considering rehab at some point during that jail sanction is an appropriate step to take. Again, given the lack of history that he has, I think it is a good step to take to have him end the sentence in a treatment setting, to put him in a position to be successful on the probation. And I would suggest that a term of probation is appropriate. Thank you.
Thank you, Mr. Brokaw. Is there anything you wanted to say today?
I just I'm asking, like, I realized that I had a problem. Like, I'm not a bad person. I just got an addiction and I can't do it on my own. I finally realized I need some help.
Okay. I read through the report. I'm familiar with what happened in this particular case, as well as your background and your circumstances from the information in that report. And I take all of that into account along with what the lawyers have had to say here today and yourself. And, I think everybody is kind of in agreement. And I don't think it's a matter of whether you're a good person or not. I think it does come down to a substance abuse problem that you have. And so the question is, what can we do as the court to try and force the issue with you to, at least require you to get some help while you're under our jurisdiction? And then what you do with that is going to be up to you. But I do think the recommendation is appropriate. I think, there are some indicators you were successful on 7411. The delay didn't go as well as Mr. Rolla pointed out, but yeah, I think there's certainly indications that you can be successful on probation and that hopefully you can use the resources that will be available to you to get help for yourself. I do think some punishment is appropriate as well. You've had some opportunities to kind of correct things before now, and that hasn't happened. So at this point, I think some punishment is appropriate with the opportunity for treatment as part of that. So I think generally the recommendation is well crafted. The court is going to follow it to the extent that I am going to place you on probation for a period of 18 months. You do have, the court's going to adopt as the conditions of the probation, all the terms and conditions that are listed in the report. The court is going to order that you serve 6 months in the Otsego County Jail with credit for 12 days served. The court would allow you to be released to treatment after 90 days. So if you can find a bed at a residential or inpatient treatment facility after that first 90 days, then I would allow you to be released from the jail. If you successfully complete that treatment, any remaining time on that 6 months, the court would hold in abeyance, and you would get credit for the time that you were in treatment. If you didn't successfully complete treatment, you'd be returned to the jail and you have to finish that 6 months. And you wouldn't get credit for the time that you were out during treatment, okay? The court is going to impose a crime victims assessment of $130. Court costs of $325, attorney fees of $350, $68 state cost, and supervision fee of $30 per month while you're on probation. I'm sure Mr. Trush has kind of discussed this with you, but you're starting to amass enough of a record now where your guidelines are going up, and your chances that probation and short jail sentences are running out really quick. So I hope that you take advantage this time of treatment, and that you're able to successfully complete your probation, because otherwise you're starting to get in that area where you may have to go to prison. I don't think you want to do that. That's not going to be good for you, certainly. So that is the sentence of the court. You do have the ability to seek an appeal of the sentence. Mr. Trush, have you been able to provide those appellate rights to Mr. Brewer?
I did. We went over them. He acknowledged the receipt of them, and I returned that to the court already.
Mr. Roll, anything else we need to address in this case from your standpoint?
Not from people, thank you.
Mr. Trush?
Does the court want me to prepare the sentence addendum order regarding rehab that we typically do?
Please, yeah, and I've indicated to the jail here that he's eligible for release to treatment after 90 days. Good luck to you going forward, Mr. Brokaw.
Thank you, Your Honor.
And that right there, it's the heartbreaking reality of addiction meeting accountability. Jeremy Brokaw's story isn't just another courtroom sentence. It's a man standing at the edge of two paths, recovery or destruction. The judge could have easily thrown him in prison, but instead, he gave Jeremy a lifeline. 6 months in jail with a chance at treatment after 90 days. This wasn't mercy, it was a test. The judge made it clear, you're running out of chances. That line hits hard because it's true for so many who think they can outsmart their addiction. One overdose, one relapse, and it's over. What's powerful here is how the judge balanced punishment with compassion. He didn't just see a criminal, he saw a broken man, still worth saving. And Jeremy's tearful admission, Christ, I can't do it on my own, might just be the moment his life turns around, or the last warning he ever gets. What do you think? Should the judge have trusted him again? Or was this just another empty promise from an addict? Drop your thoughts below. And if you want to see more courtroom moments where justice and emotion collide, make sure to like, share, and subscribe, because the next case, it's even more intense.